So you got hurt on the job, maybe severely, and you have gone to the emergency room or you have seen some other doctor, and you're afraid of upsetting your employer, and you're concerned that this might mess up their safety record or it might mess up your relationship. And so when you go to the emergency room, when you go to the doctor, you don't tell them that you got hurt at work, or you tell them, yes, I had a traumatic injury, but it was at home. And I'm here to tell you, as a workers' compensation attorney, that it's a bad idea for a number of reasons that we're going to get into today. I'm Joe Miller. I'm a workers' compensation attorney in both Virginia and North Carolina. And that's what I want to talk to you a little bit about today, which is giving a good history to all of your healthcare providers that you see for your workers' compensation injury. So I cannot tell you how many cases that we pass up on, quite a few, because we come to find out either there is no mention whatsoever in the records about getting hurt anywhere, or there may even be specific denials of getting hurt on the job. And so what the client is telling us and what is in the records is not matching up. And that creates a difficult situation. And in almost all of those type of cases, we're going to reject the case because we're not going to be able to bring a claim. It's important that you or someone on your behalf tell them what exactly happened. And it doesn't have to go into extreme detail. It just has to be a concise statement of what happened, and most importantly, when it happened, the date on when it happened, and what was being done, and also a specific time. In other words, this happened in the evening, and it happened at a particular time. Why is that? Because, as I've explained in many other videos, on our website and on YouTube and all over the internet, that in most cases in Virginia, you need to have a specific traumatic event that occurs at a specific time in order to have a compensable claim, meaning a viable claim. So, I know it's hard sometimes because folks think that these things might cause some friction between them and their employer, but I'm here to tell you that these are your rights, and if you want to enforce them, this is what you have to do. I mean, we don't know what's going to happen. I mean, it could be that a couple months down the line, 3-4 months down the line, something that you thought was going to be not much of an injury turns out to be something, God forbid, debilitating, and something that takes you out of work on a permanent basis. And if you have not given a good, consistent history to your healthcare providers, I'm here to tell you that that is the death knell for your claim. I've seen many claims from the commission, both Virginia and North Carolina. The commissioners will look at that and they want to see, has this person given a consistent history? Is what they are saying on their claim form, or in North Carolina, their Form 18, the same thing that is being said to their doctors in the emergency room and in the office notes of their main treating physicians? And if those things do not match up, you're going to have a problem. And the commissioner in those cases is most likely going to reject the claim for lack of, for failing to give an appropriate history to your healthcare providers. Don't assume that the next healthcare provider that you see is going to have the history from the last person that you saw. When you go, let's say, from the emergency room, now you start seeing a treating doctor, and that doctor's creating office notes. Don't assume that he knows anything from the emergency room. He may eventually, but when you walk into his or her office, that first visit, they're going to ask you what happened, and you're going to want to be able to tell them, and you're going to want to have that same concise history that you gave in the emergency room or whatever previous healthcare provider you saw before you saw that doctor. So, number one, you want to make sure you give a good history. Number two, you want to make sure it's the same for each provider. And number three, you want to make sure it mentions a specific date and a specific time, because that's a requirement to be compensable in both Virginia and North Carolina. Again, this is Joe Miller, workers' compensation attorney in both Virginia and North Carolina. I hope this has been helpful to you, and I hope you'll take it to heart if in the event that you or a loved one have been hurt on the job. Thank you for your time. Thanks for listening. Have a great day.